today's post-cabinet press briefing. We have today an abundance of riches in the National Security Minister, the Attorney General, the Acting Prime Minister, Minister of Finance, the Minister of Works and Transport, and the Minister in the Office of the Prime Minister. So we are going to start today with the Acting Prime Minister and Minister of Finance, and then we'll move on to the other ministers. Mr.
Thank you. My purpose here is in my other capacity as Minister of Finance. There is a news report this morning, an article in The Guardian, I believe, dealing with recently published financials of CLICO. And the article gives the impression that CLICO made a profit of $5 billion for 2014, which has led to speculation as to whether CLICO should be removed from under the control of the central bank, and so on. Now, that essentially was simply a paper transaction. The $5 billion profit, so-called profit, was really bringing to book the proceeds of the sale of the methanol company, MHTL, the shares in the methanol company. And it's just an accounting transaction. It doesn't assist Colonial Life in the manner in which the news story implies. The deficit at the end of 2014, the balance sheet deficit at the end of 2014 for Colonial Life was minus $934 million in deficit. Because although they had a profit, they also had a loss of income of $4.7 billion. So that in 2013, the balance sheet deficit of Colonial Life was $1.1 billion, and in 2014, $934 million in deficit. So there was no significant change. So it's just an accounting transaction. Based on all the information available to me, Colonial Life is still insolvent because its liabilities exceed its assets. So I just thought I would clear that up so that people would not go away with the impression that CLICO is now back into credit, back into the black, as they say, and that the balance sheet is now in credit. It is not. It is still in deficit of about $1 billion. So that's the purpose of my attendance at the press conference today. And I'll answer any questions on that issue in due course. I would allow the other ministers to complete their presentations.
Thank you, Prime Minister. Minister Dinard.
Good afternoon all, and good afternoon to the listening public of Trinidad and Tobago. My purpose this afternoon is to really share some light on the Strategic Services Agency. And I just want to go back a little bit of a history in that when this government took over in September, and in an examination of the national security apparatus, we found that there was a situation in which there wasn't an integrated approach to dealing with crime and security. And so what we plan to do and what we have done is to enhance the Strategic Services Agency by incorporating on a legal framework the National Operations Center and the National Security Training Academy. But more importantly is to give that structure that can deal with crime and criminality in a coordinated and integrated approach. And so you would realize that the responsibility of the Strategic Services Agency is in fact conducting and coordinating an intelligence approach in dealing with crime and criminality in Trinidad and Tobago. The main task really is to deal with analyzing and reducing identified threats, providing surveillance and protection, ensuring effective crisis management, and of course the whole integrations of intelligence. And to that respect, we have in fact included all the agencies with respect to intelligence gathering within the national security framework. We have in fact even included now the prisons, which we feel is in fact a very important source of intelligence in the fight against crime. There's an issue with respect to staffing in the Strategic Services Agency. And I just draw reference to the Strategic Services Act, Chapter 5, in fact, which says that the agency may employ staff as it considers necessary for the due performance of its duties and functions. And so the agency, as it restructures and has continued to deal with issues, is in fact continuing to recruit staff that can function with the remit of the agency. I also want to talk a little bit about the crime rate as it stands right now. The figure today speaks to about almost 163 persons who have been killed to date. And our strategies going forward is really to look at four strategy areas, which is one in terms of prediction, which leads to intelligence. Two, in terms of deterrence, which again speaks to presence in a number of different areas. The third one is detection, which means that we have to be able to detect what we discover. And the fourth one deals with prosecution, which is really the end state. And so those are the strategies going forward. And to sort of fit those strategies, we have, in fact, launched an exercise, which we have seen. We've got some results with respect to the Laventille, where we've had the joint Army-Police presence in Laventille. And based on feedback we've had, it has been successful. While there may have been some murders that have taken place, in the main, based on feedback from the residents themselves, it has been successful. And we continue to enhance that operation, also with the view of spreading that kind of operation into enterprise and other areas in Trinidad and Tobago. But additional to that, we have also increased our coastal presence, and you would have seen quite recently the Coast Guard, in fact, intercepted the 1.5 million worth of drugs at the southwestern peninsula in the Sijas-Icacos area. But we're combining that, the maritime operation, with also a land-based operation and a joint Army police patrols on the land base to coordinate with the maritime aspect. We've also looked at, in fact, of the seizure of guns. To date, we have seized 276 weapons off the streets of Trinidad and Tobago, and we continue that drive. So it's a sort of a simultaneous approach in terms of dealing with the guns and dealing with the gangs and so on. We're also, in fact, looking at the whole aspect of school violence, and recently you would have heard Cabinet approve the Child Protection Unit of the Trinidad and Tobago Police Service. That is being staffed, and so we're also going to have some interventions in that regard. So to sum up, we're having an increased presence in terms of deterrence. We're looking to increase our detection rate, and of course, in our intelligence gathering, in a coordinated and integrated approach to dealing with the issues of crime in Trinidad and Tobago.
Thank you, Minister A.J.
Thank you. Good afternoon, everyone. Permit me to address a few of the issues put into the public domain about the SSA again, and in particular the allegations made against the bill in Parliament brought by the opposition into the public domain. I'd like to break it down as simply as possible. The bill before the Parliament is one which seeks to amend in main form the broadening of the definition of serious crime so that the SSA can have the ability to coordinate intelligence functions under the laws of Trinidad and Tobago in relation to a host of crimes. Previously and currently, the Act deals solely with drug-related matters. Now, I want to put it this way. Drug-related matters basically encompass everything. Associated with guns, with drugs are guns, trafficking in persons, corruption, money laundering, etc. And what you will find is that the SSA currently, on the basis of that authority, has been engaged in activities of a fairly wide range of surveillance. That is to be found in terms of evidence of what they actually do in the annual reports of the SSA in the period 2009 and come to date. You will see the typologies that have been examined. On coming into government, we recognized a very significant problem, that there's a siloing of information. There are many agencies authorized by law to conduct intelligence-driven activities. They include several divisions of the police service, several divisions of the defense force, in the main. For instance, the Criminal Investigation Unit, the Anti-Narcotics Unit, the Financial Intelligence Bureau, all of these agencies have supervision and can engage in intelligence-driven surveillance. These agencies, however, the left hand seemed not to talk to the right hand. And that is evidenced when you look at what the results of intelligence produce. the Trinidad and Tobago Police Service has the obligation to actually prosecute the detection and conviction. Intelligence is handed over to that agency. But our country says, quite rightly, well, what are we seeing? Are people being put before the courts? What does the conviction and detection statistics look like? We also inherited, on coming into office, a multi-billion-dollar entity referred to as the National Operations Center. Specifically, the last government acquired an intelligence system from Huawei Technologies. That system is placed at Knowlesley Building around the Savannah. They also had in operation at the NOC several helicopters and the DAT, the Direct Action Task Force, that SORT used to have at one point in time. That was parked under the auspices of the Prime Minister's office. We believe that it is not an appropriate thing to have the Prime Minister's office managing security assets or dealing with intelligence activities. And so, in seeking to make sure that the information was shared in a responsible and safe environment, and that the National Operations Center could be utilized appropriately as it is intended to be, we sought to bring all of those under one umbrella in the SSA. That's the background behind it. The opposition has come forward and said that this is a spy agency. They have sought to tell the media, watch out and be wary. They've said it's spy versus spy. And in essence, they have created a great deal of fear around the progress of this legislation. We wish to refute that fundamentally by reference to the existing laws of Trinidad and Tobago. The only way that surveillance is permitted on anyone, any ordinary citizen, the media, anyone, is under the Interception of Communication Act. Specifically, Section 6 of the Interception of Communication Act recognizes that you may approach the court by way of a warrant, and then a judge says that you can engage in surveillance, and that authorized officers can engage in surveillance for very limited purposes of national security as defined in the legislation. That, ladies and gentlemen, is a fact of law which has existed since 2010. It was brought to the Parliament by the then Attorney General, Anand Ramlogan. The PNM, in opposition, supported the legislation. The term authorized officer, the people who can engage in surveillance, is defined in the 2010 Act as being the Defense Force, Commissioner of Police, and the Director of the SSA. We supported it in opposition because we believe that it is appropriate for the Director of the SSA, under the watchful supervision of a judicial warrant and under the watchful supervision of Section 20 of the Interception of Communication Act, which says what you must do with evidence that is collected and how it is to be viewed and destroyed. We believe that it is appropriate to maintain exactly what we inherited in terms of the laws put for this country's benefit in 2010 by the UNC. That, ladies and gentlemen, therefore makes it an extremely ridiculous position to now listen to the opposition tell the country that there is going to be spying. The fact is, the Interception of Communication Act is the only way this can be done. The fact is, a judge supervises. The fact is, there is a procedure for the viewing and the destruction of evidence obtained under Section 6. So I'd like to just dismiss that out of hand. I was reminded by the Prime Minister that it is very important that we bear in mind that the opposition has said to this country that they will not be supporting legislation. I want to invite you to reflect upon the fact that anything to deal with arrests, prosecution, and conviction are not conducted by the SSA. They are not conducted by politicians. Those matters are matters for the Trinidad and Tobago Police Service and for the Director of Public Prosecutions. When one looks to what statistics look like, you must refer to the divisions responsible for that. But I want you to bear in mind that in driving the solution to improving detection and conviction by the police service that we took a very important step in the Parliament, and that was to allow for the faster appointment of a Commissioner of Police. I would like to say publicly today that the country should be well aware that the opposition intends to be obstructionist. They have in fact sued and brought litigation. Member of Parliament Barry Padarat is a claimant against the appointment mechanism for appointment of a Commissioner of Police. And one has to therefore wonder if the opposition to the SSA bill is a mere extension of the last government, the now opposition's intention to obstruct the passage of laws which are intended to deal with crime and criminality. We see it as a very noble purpose to allow for intelligence to be collated in an effective fashion. We wish to remind the population that when kidnapping for ransom was reduced to 0, that happened under intelligence-driven policing by the assistance of the Special Anti-Crime Unit. It is for the opposition to answer why they are so disturbed by allowing for investigation under the Interception of Communication Act to deal with corruption, money laundering, and criminality in general. I just felt it important, and I thank you for the opportunity to address those issues with you so that we could return some sobriety to the argument, and I would certainly be happy to take any questions that you may have after.
Thank you, E.G. I will next hear from Minister Stuart Young.
Good afternoon, members of the media, listening public, and right-thinking citizens of Trinidad and Tobago. Just to supplement very, very briefly to the eloquence of the Attorney General, I think it's important when considering the proposed SAS bill that the public is made aware, the SSA bill, that the public is made aware of the misleading misinformation being put in the public domain. The bill is a simple one. It has 5 clauses. The main purpose of the bill is to expand the remit of serious crimes. Who can argue in relation to the expansion of serious crimes? I've heard arguments about lack of accountability. Completely untrue. There are 2 levels of accountability that the SSA is susceptible to. When you go to the parent legislation, the first is that the select committees of Parliament, and there are 2 in this instance, have jurisdiction over the SSA. The first is actually led by independent Senator Roach, which is the statutory authority's parliamentary committee. He has remit over the SSA as it is a statutory authority. The second is, of course, national security. So that is the first level of accountability. At the highest level, the Joint Select Committees, I'm reminded by the Attorney General, at the highest level of Parliament. From a financial point of view, they are governed by and susceptible to the jurisdiction of the Auditor General. And you all would be familiar that the Auditor General has the power to appoint independent private auditors if he or she sees fit. So that deals with the accountability and transparency point of view. It is also, in my respectful view, very, very important that the public understands that the SSA legislation, and in particular these amendments, do not enable the SSA to do any interception of communications. All interception of communication is done via a specific piece of legislation called the Interception of Communication Act, which authorizes, as the Attorney General has said, the Chief of Defense Staff, the head of the police service, who's the commissioner of the police service, as well as the director of the SSA, in specific circumstances to intercept communication. It also carries with it criminal penalties if there's any illegal interception done, and more so if in your interception you stray beyond the remit and parameters of what you're legally entitled to. It dictates that it must be immediately destroyed, and failure to do so carries criminal prosecution and conviction hanging over your head. So it is important that people understand that there is already a parent legislation, a parent act that is in place. And as the Attorney General said, it was driven by the Kamala Prasad Bissessar-led administration. Another issue that we've seen reporting in today's newspaper is an allegation, and it started last night circulating in the media, is a suggestion that at the Trinidad and Tobago Publishers and Broadcasters Association dinner, which took place a couple nights ago, a statement attributed to the president, Mr. Darren Leasing. Today, a press release has been issued by the TTPBA, dated the 5th of May, that sets out that there seems to be some confusion. His comments were really related to the cybercrime bill, which is not back up on the legislative agenda, but is something that we are looking at and that we intend to drive forward. So the comments that were put forward in relation and attributed to him for the SSA are not, in fact, with the SSA, is to do with cybercrime. And how the confusion arose is in serious crime, of course, you now have the element of cybercrime. As the Attorney General is saying, it is on our legislative agenda. What I meant, it is not laid before Parliament for debate. So there's not yet a bill before Parliament for discourse and consultation, which will come in due course. So ladies and gentlemen, it appears, and we hope to debunk all of the fear-mongering that is taking place. There is no need for fear. It is only persons who are engaged in serious criminal activity should fear the expansion of the remit of the SSA. But it is important as well to note that there is already legislation in place that governs and dictates how one intercepts communication, and it is not limited only to the SSA. It also permits both the police and the defense force to gather intelligence. Thank you very much, ladies and gentlemen.
Thank you, Minister Young. And now we have Mr. Fitzgerald Hine, the Minister of Works and Transport.
Thank you very much. Ladies and gentlemen of the media and citizens of Trinidad and Tobago, on the 29th of April 2016, a major advancement regarding the safety of the use of the nation's roads was happily implemented through the Ministry of Works. On that day, I announced to the media and the public that we had signed the order, and on that day, the order was published to give effect to the use of speed measuring devices which would detect excessive speeding on our nation's roadways and, of course, at the same time, hopefully act as a serious deterrent to those who are so minded to do at all of our pain and detriment. This was necessary because the citizens of the country were literally crying out, as many of us perished on the nation's roadways. To date, we have about 51 or 52 road deaths as I speak to you. And it is in response to those cries that we hastened to make effective that order and to allow legally the use of these speed measuring devices. I am told from the police and the traffic management professionals at the Ministry of Works and Transport that the deterrent effect seems to have come into play, in the sense that it is observed that people have slowed down tremendously on the nation's roads, and that is a good thing. It is worthy of tremendous celebration. I saw yesterday actually, we had another road death where one driver crossed the median, collided with another vehicle, and one person lost their lives. We are hoping that this deterrent effect will impact on all of us so that we will make the roads a little bit safer. There is some discrepancy in the national community, perhaps based on 2 newspaper reports published today, perhaps out of a comment made by one ASP peer at the police's weekly briefing, where he indicated, or at least implied, at the very least, that there was some time lapse between the legalization of the use of speed guns and the prosecution of offenders with the use of same. The Commissioner of Police, having learned of it a very short while later, corrected it very satisfactorily. So it is the police's accurate and final position that since these instruments have been given legal effect, they are in use, in application in Trinidad and Tobago. So the public should be under no misapprehension. It is the law of Trinidad and Tobago. It was always the law, actually, that you should not exceed the speed limits. All these devices did was to allow law enforcement a more efficient and modern means of detecting the excessive speeding and prosecuting them. So the public must be under no misapprehension. These instruments are on the nation's roads, and the police have been trained. They are now well equipped to carry out their duties in this regard. There is absolutely no difficulty with that, and for the time being, we at the Ministry of Works and the government is quite happy at these developments, and we urge the police to continue to do their work as proficiently as we know they can.
Thank you, Minister. We now will take your questions. Just first identify the minister to whom the question is being asked, and then proceed. Thank you.
Jewel Brown, TV6 News. Question to the Works Minister. I know this question was posed to you already, but just to see if there's any update. This petition online for the government to consider increasing the speed limit on highways to 120 kilometers an hour, is that something the government would be looking at all?
As a very listening government, and one steeped in the essence of democratic principles, we are always open to suggestions. I said then, as I repeat now, we would continue to listen to what the public has to say. Such a petition is not outside of that. We would listen, and the experts in the ministry, and even those outside who are willing to share their expertise, will comment upon these things going forward.
Any sense of whether or not you would be able to say if there would be a time at which you'd be able to announce, okay, the government has examined this and we will come to a decision on the matter?
Now is the time. It's a process it's a work in progress. It's always under review. But we are very impressed with the fact that so far, drivers on the roads, I saw it reported in the media last night, have discernibly slowed down, and we are very happy about that.
There was a story in the Guardian newspaper concerning the acquisition of speed guns and whether or not there should have been X amount, and apparently there was an issue with the contract of supply. Could you clarify that, sir?
Well, I'll tell you as much. As far as I'm aware, there are 6 of these instruments in the hands of the police today. There were obviously attempts to procure more of these instruments in a time past before this government took office. I'm aware that there were 2 efforts to procure more of these devices. Those processes collapsed. The police commissioner purchased 6 of them. He used them to train the requisite number of officers in their use. They are in circulation at the moment, and as soon as the police commissioner demonstrates that he requires more, efforts will be made to procure more in terms. The cabinet took a decision just about a week ago that the procurement of these devices would be handled through the Ministry of Works and Transport, and we stand ready to carry out cabinet's dictate in this regard by open tender, of course, competitive tender.
There's a question to the acting Prime Minister in your capacity as Finance Minister. So if you are saying that Colonial Life is still insolvent, then what would be the way forward in dealing with that particular matter, given the amount of money the state had put into the bailout?
Okay, just let me further clarify what happened and why there could be this mistaken impression that CLICO is suddenly a profitable entity. When a company such as CLICO has assets such as shares in another company, they are treated on the books as comprehensive income, also known as unrealized gains. So CLICO would have acquired these shares long ago at a lower price, and the shares would appreciate in value. So on the books of CLICO, as the shares in the methanol company appreciate in value, it will be an unrealized gain on the books of Colonial Life, and that's under the heading comprehensive income. When these shares are sold, the amount that is listed under comprehensive income goes down by the amount that the shares were sold for, and then that cash is transferred to the balance sheet in terms of income. So it's really moving it from one categorization in CLICO's books as unrealized gains to another one as actual income from the sale of the shares. The net effect of it all is that CLICO is still insolvent to the tune of about $1 billion. The central bank has a resolution plan. According to the legislation, the central bank has to submit to Parliament on a regular basis, the resolution plan. It has to submit this plan to the court, and the central bank is continuing in accordance with the resolution plan that was laid in Parliament some months ago. In fact, I just received an update on that, and I will be laying it in Parliament, or causing it to be laid in Parliament in the next couple of weeks, the latest update on the CLICO resolution plan. But that's for Colonial Life. That's only for the Colonial Life Insurance Company. It has assets, it has liabilities. And the plan is to dispose of the assets to meet the liabilities. Okay? So then that clears that up.
Just a follow-up question to that, Minister Imbert. At last week's post-cabinet news conference, you spoke of the commissioning of a forensic audit.
Correct.
Right? Is there any update on that as yet?
Yes, I have. There is a company that has been working with the Ministry of Finance, that's Ernst & Young. They had already done work for the former administration, the former Minister of Finance, the former government, with respect to assets and liabilities of, the actual total amount of money, let's put it that way, put into the CLICO bailout. And I've asked them to update their records. Their records had showed approximately $24 billion was put in. It's made up in different ways. Actual cash put in, and something called contingencies and contingent liabilities. So I've asked Ernst & Young to update the last report they made to the previous Minister of Finance, and I will expect to get that soon. So that's in progress.
On the issue of the SSA bill, this question is for either Minister Al-Rawi or Minister Young. You spoke a lot about the opposition's objection to this bill, but several oppositions, at least two opposition senators have also, have raised some concern about the bill, in particular the issue of oversight and monitoring. So this is not just an opposition issue that they're raising objection. Independent senators are also concerned. And I'm wondering if you've read some of their concerns outlined in the papers today, and how do you respond to some of them?
Sure. I had the pleasure of sitting opposite the independent senators whilst they made their submissions. So more than reading it, I heard it. There were two independent senators who indicated a willingness to support the legislation but expressed certain concerns. And there were two independent senators who indicated that they were not prepared to support the legislation. With respect to one of those independent senators, the expression was that because there had been no arrest and conviction, that he was not persuaded that more power should be given to the SSA. Of course, the problem with that particular point of view is that it doesn't factor the fact that the SSA never is engaged in arrest and conviction. That is a matter for the Trinidad and Tobago Police Service. So regrettably, I think that is not yet made clear enough to the Honourable Independent Senator, and certainly I do intend to clarify that, because his focus was against efficiency, which is really the domain of the Trinidad and Tobago Police Service. They must explain themselves. With respect to another senator, Senator Ramkisoon, she gave 5 reasons why she felt she could not support the legislation, some of which I have addressed in my run-up a little bit earlier. But beyond the independent senators, and I certainly intend to respond to the issues raised by them, because I think that it is more a matter of a need for better clarification and explanation, and perhaps they may be persuaded to lend support after that happens. But with respect specifically to the other observation made by the publishers group, I wish to put onto the record the following. The last government brought to Parliament a very contentious piece of law called the Cybercrime Bill. It was associated with another piece of law called the Cybercrime Agency Bill. Those laws were debated, and the media, international media and local media, made serious objection to the concept of an intrusion into the rights of the press, the freedom of press. Those bills were allowed to lapse. If you look to the legislative agenda, the published legislative agenda of this government, you will note that we have specifically identified cybercrime as bill number 3 in our run-up schedule. We are actively addressing the media's concerns in relation to cybercrime, and the views expressed by the Publishers Association do not in any way intrude upon the SSA bill, because there is no law in relation to cybercrime which could prejudice the media. There is, however, computer misuse, which is in the definition of serious offenses, and there is a reference to cybercrime only in what we call the common law reference. And that common law reference is to take care of the work which the Cybercrime Agency of the Trinidad and Tobago Police Service investigates. And that is, for instance, the traditional methods of harassment, etc., put on a virtual environment. So there's nothing to deal with the media. There is one other piece of law. It's the Data Protection Act. And the Data Protection Act has not been fully operationalized. And we intend to bring a specific amendment to the Data Protection Act to take care of an unconstitutionality which we observed whilst we were in opposition, as it relates specifically to intrusion on the media rights. So far from advancing the position which the opposition suggests, we have demonstrated on our legislative agenda, and as I've just told you, a very purposeful tract to ensure protection of media rights, but they have nothing to do with the SSA bill.
If I may briefly add, just to answer your question on the oversight. I think we had touched on that earlier. The oversight is already provided in the parent legislation via both the Joint Select Committees of Parliament as well as the Auditor General. And then, well, before going for a warrant, you have to, of course, go to a judge to get the warrant.
But the issue of the appointment of a director of the SSA is still something that has not necessarily been addressed, because I think there is a concern that it should be appointed by the Parliament itself and not necessarily the Cabinet. And also termination of SSA staff should be done by the Parliament to ensure there is no, the President, to ensure there is no political interference.
Sure, just to let you know, what's before the Parliament is a 5-clause bill. Clause 1, the title. Clause 2, that it should be a proclamation date. Clause 3, 4, and 5. 3, 4, and 5 is 1, to amend the definition section, 2, to amend the function section by including the new defined term serious crime, and 3, to put into effect the proceeds of crime seized asset fund, which we have operationalized for the first time ever. That's as narrow as it is. The bill does not seek to intrude upon the appointment of a director, because that's the existing law since 1995, when the bill was piloted by Minister John Eckstein, Minister of National Security then. We accepted the position since 1995 that that is a robust provision, and we accepted the UNC's advocacy, which was exactly the same in the period 2010 to 2015, and I will remind you, even when the issue of the director arose with the very unfortunate appointment of Reshmi Ramnarayan, we understood that there was a mechanism to deal with that, which is still available. So we have certainly also had a look at all jurisdictions where agencies of this type are involved. Some of them prescribe alternate formulas, but the vast majority of them, and in particular the United States of America, etc., allow for the appointment of a director in similar fashion to that which has been the law of Trinidad and Tobago since 1995.
Before Mr. Hines goes in, just let me see if I could simplify that. What the AG is saying is that the arrangements for the appointment of the head of the SSA have been in existence for 21 years and have passed through the Manning administration, the Pandey administration, and the Prasad Besessa administration without any adverse comment, and therefore for it to come up now 21 years later as a big issue is a bit surprising. It's nothing new. It's been there for 21 years and nobody complained about it before.
Thank you very much, Mr. Prime Minister. It's not simply surprising for me, it is blatantly hypocritical. You know, I read into the Parliament record when I contributed to this very important debate that in the United Kingdom, their intelligence gathering agency akin to our SSA reports directly to the Prime Minister of that country. I read into the record the same in respect of Australia. This is nothing unique to Trinidad and Tobago. The Attorney General is quite right. This is a system that has been engaging us now, as it is, for 21 years. And finally, I would like to say that I cannot understand, you know, All this bill is doing, as the Attorney General explained, is widening the remit, the definition. The SSA was there, it is still there. It was dealing only with drugs and drug trafficking. We are now saying it should deal with a host of other offenses, and that is for the benefit and the betterment of the people of Trinidad and Tobago. Nothing new, nothing strange. It is all hypocrisy in my honest view.
Last word to add in on that particular point, if I may. We are doing that specifically because other agencies are dealing with that subject matter, and it's important for the left hand and right hand to speak to each other. It is not something that is new. It is only to make sure that it is efficiently managed. So in broadening the definition, we are not doing something which is new. It's in fact being done already. Look to the SSA annual reports and you will see that. What is important to do is to put it into law so that the other agencies can speak to each other under one umbrella. The international partners of Trinidad and Tobago that are assisting our country with security and intelligence measures, which help us to deal with drugs, guns, ammunition, and criminality of all forms, tell us that it is imperative for us as a country, if we wish to have their cooperation, that we centralize our activities and put it under one agency. That is not an easy submission to ignore, because it is important that you have a vetted, clean environment so that information can be managed securely and passed over to the requisite authorities who can prosecute it, being the police, etc. Thank you.
If I may add also, just a bit to what the AG has said, in terms of what is most fundamental is that we have now put these agencies into a legal framework. Because you could recall some time ago that there was a time when we said that Special Anti-Crime Unit was in fact illegal and so on. The structure that we have in place is now under a legal framework governed by the SSA Act. The NOC is now placed within that. The National Training and Security Academy is placed within that framework. So now, in terms of dealing with our international partners, they now have a legal entity to treat it insofar as information sharing, intelligence sharing is concerned. I just thought I would add that. Thank you.
If I may ask. Oh,
just 1 second. Thank you. I simply wanted to ask, as I asked myself aloud, what are they afraid of?
The opposition circulated some amendments in the Senate on Tuesday. I was wondering if the government might look at those amendments in light of the fact that even some independent senators have urged the government to consider some of the proposals.
Sure. Definitely, we are looking at it. We're very relieved to finally receive something from them, because it was on the Parliament floor that Senator Mark circulated amendments. We had asked the Leader of the Opposition to give us amendments. She said to us that we should draft it for her. We thought that that was rather unfortunate, but we're grateful to have received it, and we're certainly looking at it.
One of the proposed amendments relates to the same question of the appointment of the director that was just raised. I was wondering if the expansion of the scope of the SSA to include serious offenses, which is a pretty wide category, does not substantially change the nature of the SSA and therefore require a higher standard to be imposed in relation to the appointment of a director.
Two things I can say in relation to that. Everything by way of serious offenses can fall under the umbrella of drug-related activity. One can make an allegation that firearms are involved in drugs, trafficking in humans are involved in drugs, corruption, money laundering, because you have to follow the drug money as well under drugs. So everything that is under serious crime can fit neatly under the existing umbrella of drugs. One needs only to just say that that is reasonable belief, and a judge needs to approve that. So that argument doesn't go that far. On the other hand, the specific point of the standards made,
of the director,
made by the opposition, quite unfortunately, none of those recommendations are the substance of the bill. What they're asking us to do, and which we're certainly looking at, is to come with another host of amendments, which certainly we'll be prepared to look at. This is the first time that we've seen amendments of this type. I have in my possession the working documents of the UNC, Mrs. Prasad Bisessa's team under the National Security Council, 2012, 2013, 2014, which makes specific suggestions for the amendment of the SSA Act, none of the amendments circulated by Senator Mark are in any of those working documents produced by their own experts. So we'll certainly have a look at it.
Do you
Thank
think
you.
the president should be given the ultimate discretion to make the appointment to the directorship?
We're going to compare that against international best practice and have a look at it certainly and come back with a point.
Just two more questions. In relation to CLICO, Minister Imbert, is there any word on the Coleman report?
I got a message, and I'm told that the report will be available shortly. When was the day?
End of the month.
It is hoped that the Coleman report will be delivered by the end of this month, but apparently, should I say that? Okay. So that it is hoped that we'll get it by the end of this month. But I have asked the AG specifically to see if we can fast track, and the response I got is that, barring unforeseen circumstances, remember this is the report of an independent commission. It's not the government's report. This is the report of Sir Coleman himself. So that we have asked that the report be expedited, that come in as soon as possible, but we wouldn't want him to act in haste, and we've been told at the end of this month. Okay?
Sir Anthony had previously expressed concerns over a lack of resources. Were those concerns addressed, and how?
I can say insofar as the office of the Prime Minister is the one that enables a commission of inquiry's purpose, Sir Anthony had made a very stinging criticism against several attorneys well known to us by the last administration, that they had failed to do any work and that in fact he fell upon one person only. I can tell you as a matter of fact that Sir Anthony has requested many things of the government, all of which have been supplied to him, and that the position is that the indication as we have had it returned is that the report will be ready by the end of this month, and that they are all set for that.
Just
Okay.
finally for me, just because it was raised yesterday in relation to the SSA discussion, the opposition has questioned the appointment of Mr. Fitzgerald Hines as the chairman of the Joint Select Committee on National Security. They have said that this is not best practice because it should be an independent person, seeing that it's an oversight committee. How does Mr. Imbert reply to this?
I will answer that. There are a number of joint select committees, and the government chairs 3 of them, I believe. I chair the Committee on Energy Affairs. Mr. Hines is National Security, and there's a third one which escapes me right now. But that is 3 out of a large number of committees. Social, so I'm not sure what the third one is. I wouldn't want to speak out of turn. We felt that energy was sufficiently important that a government minister should chair that. We felt national security similarly. The others, we felt that they should be chaired by others. And it is not sacrosanct that none of these committees should be chaired by government members. In fact, when these committees, the constitutional committees, the Section 66A committees, were brought in by the UNC, that matter came up, and they indicated at the time that it's not something that's cast in stone. Different approaches to different things, so that the government felt there are certain committees that require a government member to chair, and I can give you the assurance that it is not that the government would be chairing these committees in order to cover up anything or prevent the examination of entities and so on, so that people should not be too worried about that.
Okay, we'll take one final question.
Right, Melissa Dastroth from C News. Jumping back to the speed gun issue, my question is either for the Works Minister or Minister of National Security. Aside from the availability of only 6 speed guns, do you think we need more police on the road as a deterrent?
Certainly. I would answer that question by saying the speed gun is just complementarity to physical presence on the roadway. And you will see an increased presence both through our rapid response unit and, of course, officers on the road. So there's a combination of both. One cannot upgrade with itself, but it's a combination of using the speed guns and, of course, physical presence on the road through our traffic branch and through our rapid response unit.
Now, I want to believe you, except from my experience in the last few days, has been that I haven't seen enough police on the roads.
I can't answer that as to what time you may be traveling, but I can tell you that there has been an increased presence and there have been instructions to that effect. So in terms of our deterrent strategy, it is based on presence in a number of different areas, not only on the road, but in various hotspots, as we call them. So the deterrence factor is always part of our strategy, and that deals with presence in certain areas at a certain point in time.
Now, another question relating to the speed gun. Is there a more subtle mechanism for monitoring the speed limit? Because I saw a few police using them and they were very large. They were like tripods. And I can only imagine if you were to see someone speeding, how would you shut this whole thing down and jump in your car and follow them and give them a ticket?
That
Mr. Hines will deal with that.
Okay, I think we have exhausted the number of... Okay, all right. Okay, Kamal.
in respect of the application of those guns on the road, the instrument can as well be handheld as well as it could be affixed to a tripod. It has the capacity to measure speed of vehicles coming towards the officer, and it has the capacity to measure speed in a vehicle going away from the officer. In respect of capture or detection or handing over the ticket, as it were, later on down the road, the way the system is designed, a police officer here measuring the speed can easily email or send this message on to the next checkpoint down the road. So when you arrive there, you will meet your ticket. Those officers would have had your number, they'd be able to stop you properly, and they would issue you with the ticket. And of course, we have the Motor Vehicles and Road Traffic Amendment in the Parliament, as we, in the hands of the Attorney General at LRC. Shortly we'll be coming to the Parliament with it, and that will permit the use of the issuance of these tickets by way of the mail. Thank you.
Okay. Yes,
So,
Kamal,
a
and then
follow-up
Ray
to
will
that
have the last
question,
question.
Minister Hines, you spoke in your contribution earlier about the fact that the consultative process was ongoing. If I'm not mistaken, you were speaking with the technocrats and so on. That's correct. But I think there was still a little
What
bit of
I did say is that everything that we do in respect of road traffic management and safety is a work in progress. It's an evolutionary process. It's always ongoing, always therefore under review.
Understood. I'm just wondering if you could be a little more specific as to at what stage are we in terms of having the discussion about addressing the speed limit. Have we already spoken to some of the stakeholders? Have we already spoken to some of the technocrats? Are we in the process of consulting, not on the general issue of road safety, but on the speed limit specifically?
You may be happy to know that this is not a new matter. These are matters that we were looking at a long time before last Friday when this order was given effect.
Okay. And the issue of the legal action taken by the 7 members of who were dismissed from the SSA Attorney General, can you respond to that? Have you received their notices, and what is the process now?
The matters have been filed, the Attorney General's office has been served, and it's engaging the attention of the office right now. It's in court. There is due process, and of course we will follow it entirely. I just want to bring something to your attention. It's not the first time someone has been dismissed from the SSA. In fact, it's not the first time that a claim has been made for dismissal. Unlike my predecessor Attorney Generals, who failed to file any defense in the claims brought against them by persons dismissed from the SSA, these will certainly be defended. The fact is that damages are now to be paid as a result of the failure of the last Attorney General to enter any defense for the dismissal of persons from the SSA by the Kamla Prasad Bisesa administration. But we are confident that there are defenses to this matter, and they'll be dealt with.
Thank you very much, Ray Davis for 102.1 FM. Minister of National Security, how near or how far are you from the matter of $1 million compensation for officers slain in the line of duty? Minister of Works and Transport, one question at a time. Thank you.
I'm pleased to inform you and of course to inform the widening public that the matter has been taken. The Cabinet is under Cabinet for deliberation at this point in time.
I have another one last question to the Minister of Works and Transport. In the context of the speed gun, Tobago has escaped this for now.
Certainly not. This law is not ad hominem to Trinidad and Tobago. It is applicable to all, to Trinidad, sorry. It is applicable to all of Trinidad and Tobago. As to the use of resources and the application of resources, that is a matter for the Commissioner of Police.
The Minister of Finance, Acting Prime Minister.
I'm sorry.
Time?
You said one. You're going to two.
One question
You're
for
going
each
to
minister.
three now?
Yes, I
Oh,
do
one
have.
for each?
Yes.
That's not what we had in mind. Go ahead. It was one from you. Go ahead.
Well, of course, Minister of Legal Affairs, the Junior Minister, you did speak to campaign finance reform in your deliberations yesterday.
Yes, sir.
How soon are we expecting this, or it may take
Well,
some-
unfortunately, I didn't see you there yesterday, but we
Oh,
launched.
Minister of
we-
Education, I went to that meeting.
All right, we launched the campaign finance reform of this government yesterday, which will be kicking off with an international conference with a host of international speakers on the 18th and 19th of May. When the Prime Minister returns, he will be opening the conference, and that is the start of the process. We have gathered all of the work done before, and then thereafter we will engage in conversation with more specific bodies that it would affect, and then we will move to policy and legislation. And we've given a guarantee, none other by the Prime Minister of Trinidad and Tobago, that before the next general election, we would have put legislation in place to deal with this issue.
Right, thank you very much. And Minister of Works and Transport, sorry again.
No,
in
no,
the
I'm
context,
sorry. No, one. It was actually one question from you. We've expanded it to
Thank
one
you very
per
much.
minister. You asked him one already.
Yes, thank
So-
you very much. Yeah.
You're good? All right.
Hi, good afternoon. Sonal Lala from 103 FM. I refer to this question to the Minister of Communications. I refer to an article in the Jamaica Gleaner and the Jamaica Observer this morning. It says that the Foreign Affairs Minister from Jamaica, Camilla Johnson-Smith, is she received in correspondence to, in writing to, from our Foreign Affairs Minister that TNT is actually going to retrofit a specific area in the Peoria International Airport for Jamaicans who are refused entry. And by July and by June, all immigration officers and security officers will receive customer service training. Can you confirm this?
I haven't seen the letter, and I wouldn't want to comment on something I don't know about.
Actually,
I can comment on that as the acting Minister of Foreign Affairs. It is not specifically for Jamaicans. It's for anyone who is debarred entry based on immigration status. We've treated with them in a particular way, so it's not specifically for Jamaicans. And we put in measures in place to treat with anyone so defined.